Right, welcome back to Morning Live. Now, yesterday, the South African Social Security Agency, SASSA, withdrew its constitutional court application to request the extension of a social grant distribution contract that was regarded invalid in 2014. At the same time, the Black Sash Trust, represented by the Center for Applied Legal Studies, launched a constitutional court application against SASSA to protect social grants. To talk to more about this dilemma, we joined in studio here in Johannesburg by Bonita Meyersfeld. She's the director at Center for Applied Legal Studies. Bonita, a very good morning to you, and thank you so much for coming through.
Good morning, Palesa. Thank you.
All right, kindly, bring an understanding. SASSA has withdrawn its application, and that of your clients, which is Black Sash, still stands.
Yes.
What does it entail? What does your application entail?
So the Black Sash has gone to court to ensure that or to request the court to have oversight over the next few stages of the grant beneficiary payment system. Specifically and firstly, we want to ensure that the agreement that will be entered into or renewed between CPS and SASSA is not exploitative of the government's position and is not detrimental or harmful in any way to beneficiaries. We've got a very strange situation in which the only entity, by all accounts, that can actually facilitate the payment of grants is CPS. So it's in a position which is it's a monopoly at the moment where it is really able to demand any terms. So the first point we really are asking the court is to ensure that CPS also understands its constitutional obligations under the Constitution to provide social grant services in a manner that is not exploitative. Our second main concern is that the personal data of beneficiaries is kept confidential and not sold on to affiliate companies in a manner that could allow pernicious, targeted marketing, which has a very detrimental effect on the extent to which grant beneficiaries are able to get their grants without deductions. And finally, there has to be some accountability. Very clearly, there is some type of paralysis within all the state agents responsible for this. And our concern is that that paralysis needs to be broken in some way. That paralysis needs to be released, and hence our intervention to the Constitutional Court to ensure that there is some accountability going forward, but also possibly to facilitate some assistance so that the system has an oversight body in the Constitutional Court, that SASSA comes regularly over the next year to the Constitutional Court to explain what steps it's taking, when they're taking them, and what they seek to achieve, so that we don't land up in the situation we're in now in a year's time.
All right. So basically, your concern as Center for Applied Legal Studies, it's the fact that CPS, it's the only option that South Africa has in terms of the payment of the social grants beneficiaries. But you're saying that the court should oversee the process.
Right, so the concern is twofold. The one that you only have one entity in the country able to distribute social grants, but the other is that it's based on a contract that was declared invalid by the Constitutional Court in 2014, and that period of invalidity expires, or the court order implements that invalidity at the end of this month. So at the end of this month, there will be an unlawful contract. And our concern is that nothing was done to avoid what was a very avoidable situation. There is an urgency now that quite frankly, practically and legally, was never supposed to happen. So that's part of our concern too. And we want to ensure that this immediate moment in respect of grant payments in South Africa is not exploited, and that we don't have a crisis on our hands. We will, of course, then, because our client, the Black Sash Trust, is extremely dedicated to the grants issue, we will, going forward, also have views on the way in which grants should be distributed, who should be responsible for distributing them. But as matters stand, there is one entity responsible and capable, and that entity, we hope, will do so with respect and concern ultimately for the
All right. Now, you made mention of malicious marketing. What are you referring to?
There's a phenomenon at the moment where corporations will find this data, will buy the data of grant beneficiaries, many of whom are in far-flung areas with little or no education and little or no cell phone or IT technology capability. So they get an SMS that says opt in or opt out, and they press a wrong button, and the next thing they've actually unintentionally requested or asked for payment for cell phone data or electricity that is then deducted off their grants, resulting in their entire grant sometimes disappearing. So we're also asking the court to ensure that there is no opt-in option for grant beneficiaries, that particular bank account is ring-fenced, that particular money is ring-fenced, so you don't get malicious marketing that exploits what we know is a situation of uncertainty.
So are you saying that has happened in the past?
Very regularly,
within SASSA?
Well, as a result of the service provider, which in this instance is Cash Paymaster Services.
Right. Has it been proven?
There is a great deal of data around this. There's a great deal of research. The Black Sash Trust has offices throughout the country where we have these concerns and complaints. We have cases. And frankly, it only needs to be one person, but our view is that it's probably millions.
Now, back to the issue, Bonita. Obviously, as we said, that today marks a 30 days deadline for South African Social Security to find, a replacement.
Yeah.
Legally speaking, do you think that this issue is going to be sorted on time? I mean, we had the Deputy President in Parliament yesterday saying that, in fact, giving assurance to the beneficiaries that all will be well. But legally speaking, do you think that it's going to be sorted out?
No, I mean, we're in this untenable situation where we are going to court to ask for the confirmation and continuation of an unlawful contract.
Exactly.
And I think that's part of the anxiety everybody's feeling. Why, if 3 years ago, everybody was aware of the fact that there was an unlawful contract in place, why are we in this strange, anomalous situation where we're going to court to ask the court to continue and to allow for the continuation of an unlawful contract, albeit on terms that we are arguing would be constitutional and appropriate. But no, I don't see how the milk that has spilled can be mopped up easily before the end of this month.
But surely something has to be done. Do you believe there might be a short-term solution to the problem? I mean, the beneficiaries obviously are Diermekar as it is now.
Right, and like you said, there's a difference between practically what will happen on the 1st of April and legally what will happen on the 1st of April. Practically, most importantly, grant beneficiaries receive their grants. The legal question is, was it done through a lawful tender and in a process that is not exploitative of government or grant beneficiaries? That's our point of intervention at the court. So we're trying to ensure that the Constitutional Court has an oversight over a situation that is unlawful. But I agree with you. The most important point is that grant beneficiaries receive their grants. And to my mind, that is not the nub of the issue before Parliament and before the courts, but rather, how can we be in a situation that is very clearly both unlawful and unconstitutional?
All right, Bonita, I believe we'll wait and see what happens, but thank you so much for coming through.
Thank you.
All right, thank you very much indeed. There you have it. That's Bonita Meyersfeld. She's the director at Center for Applied Legal Studies. This is indeed a developing story, many angles coming out of it, but we'll be keeping you abreast as to how things unfold. Let's quickly take a break. You're on Morning Live. We'll be back right after this.